filed. It's happening now, and the response, or the plaintiff's response to that briefing is due on the 15th, next Friday, this coming Friday. The status of the litigation regarding the kingdom is that we've finished all the Daubert briefing, and we're waiting the court's decision. And a renewed motion to dismiss will be coming up in October, with the response from the plaintiffs in December. On the Dubai Islamic Bank issue, unfortunately, the court granted a motion to dismiss against Dubai Islamic Bank, or in favor of Dubai Islamic Bank. On the flip side, in Sudan, the court denied the motion to dismiss filed by Sudan. And on Iran, they're still in default. And I'm going to defer to Mr. Eubanks on commenting mostly about the Iran issues. On the Daubert issues, much of the time of the plaintiff's lawyers this year has been consumed, much of the attention has been consumed by doing Daubert motions. A Daubert motion is, in case you don't know, is basically it's a request by one side to kick out or limit the expert testimony of the experts on the other side. And the name comes from the court case that set the standards for how to do those motions and how to kick out or limit expert testimony. In addition to the Daubert motions, I'd be remiss if I didn't comment that much of the time of the plaintiff's lawyers and much of the time of the court this year has been addressed in working hard towards getting judgments against Iran and the Taliban. On the charity case, or the case against the charities, the Daubert work is much of what happened. In November of 2021, the parties exchanged Daubert motions. The plaintiffs tried to get out some of the charity defendant experts, and the defendants tried to get some of the plaintiffs' experts out. In April of 2023, April this year, the court issued an order on the parties' Daubert motions entirely striking one of the defense experts, a gentleman by the name of Charles Freeman. He was nixed out as one of the defendants' experts, and limiting portions of the opinions of another three defense experts, John Seidel, Jonathan Benthal, and Jonathan Marks. You'll find that Jonathan is a name that apparently is not good to be an expert, because a lot of the experts are Johns or Jonathans. The court also placed limits on the testimony of two of the plaintiff's experts, Jonathan Weiner and Brian Jenkins. There is a deadline, there was a deadline of July 31st for filing any last of the Daubert motions, and the defendants did file motions related to two more plaintiff's experts, Matt Levitt and Evan Coleman, and that's the deadline that's coming up next Friday for the plaintiffs to respond to those motions. On the kingdom track of the litigation, again, Daubert motions were filed by the kingdom and by the plaintiffs, and the plaintiffs have moved to strike a number of the kingdom's experts, and the plaintiffs moved to strike a number of the plaintiffs' experts. I think, Duke, you may have more to say about that, so I'll defer that piece to Duke to talk more about. And all the briefing on that is done. And we're, for the most part, waiting for the court to issue its decision on the Daubert briefing. And then in October, the kingdom will presumably, that's the deadline for the kingdom to file its renewed motion to dismiss, with the plaintiffs responding by December. On the Sudan track of the litigation, the court issued a ruling and recommendation in May of this year. The court issued in May of 2022, and Magistrate Judge Netburn issued an amended ruling and recommendation granting a reconsideration on a limited number of issues. The Sudan filed an objection because the court's decision basically recommended that the court enter default against Sudan, and so Sudan filed its objections. Judge Daniels held oral argument in April of this year, and in just a few weeks ago, in August 10th, the court upheld the magistrate judge's recommendation and essentially issued a default judgment against Sudan. And Sudan has since then filed a notice of appeal indicating they intend to file an appeal to the Second Circuit. On the Iran issues. On the Iran track, I'm going to defer to John to talk about. There's a few other issues addressed in this past year. One issue is the issue of the Afghanistan Bank assets and turnover proceedings there. In August 26th of 2022, just before we were here last time, Judge Netburn issued a ruling and recommendation, which is basically Judge Netburn, the magistrate judge's recommendation to the district court judge, recommending that the court dismissed some turnover proceedings filed by a subset of plaintiffs in the MDL who had judgments against the Taliban, recommending that the assets could not be used to pay down the judgments, essentially because the DAB, the Afghanistan Bank funds, the court said, were not the Taliban's. In February of this year, Judge Daniel considered Judge Netburn's recommendation, and he denied the turnover proceedings of DAB assets, making them unavailable for use to satisfy any part of any of the judgments of the 9/11 plaintiffs in the 9/11 litigation against the Taliban. A few days later, the parties to the DAB fund turnover proceedings filed a notice of appeal to the Second Circuit, where the parties, their substantive briefing has been done. There are several non-parties, what they call friends of the court or amicus parties, that are intending to file briefs, and those filings are due October 6th, and the replies would be due November 6th. And at that time, the briefing on the DAB, or the Afghanistan Bank assets turnover proceedings in front of the Second Circuit would be done. Some other non-9/11 claimants have raced outside of the MDL to get judgments against the Taliban, and they would use those to gain access to the DAB assets and other proceedings, while the MDL court has still not yet entered judgments for all of the plaintiffs in the MDL. One other issue that's taken up some time with the court since we were here last relates to a sanctions order that has resulted in some changes to the PTC. Judge Netburn issued an order proposing sanctions in relation to an incident that I think was in the media. Occurred a few years ago, where an investigator for one of the firms in the MDL was identified as having leaked documents to the media in violation of several court orders. One of the sanctions that was recommended by the court and taken up by the court was to remove certain of the lawyers from the plaintiffs' executive committees that are coordinating on behalf of all the plaintiffs. Judge Daniels held a hearing in December, and ultimately, as a result of the order that Judge Daniel entered, the lawyers from one of the firms was removed from PDCs. It's important, though, that those lawyers that were removed from the PDC continue to represent their clients, they continue to work in the litigation, and they continue to coordinate with the PDC as anticipated by the court's early case management orders. One of the other issues that happened since last year was the court ordered in the O'Neill class certification, in the O'Neill class case, one of the O'Neill cases that was filed, the court issued a decision that denied the class certification. And there's some issues that have developed or evolved from that. But I think the important thing is, as for right now, it's limited to that one case. And any of the other issues would have to be litigated in the other separate cases. One other short thing is that, I guess a positive thing is, in July, the court adopted an earlier ruling recommendation for the magistrate judge, striking one of the defendants, Wild Jaladen's answer and rendering a default judgment against Wild Jaladen, who was a contemporary of Osama bin Laden. One last issue that I wanted to address before turning the session over to my colleagues here. So I want to say a few words of introduction about a piece of legislation under consideration by Congress that you should all be showing your unqualified support for. The Ensuring Justice for Victims of Terrorism Act, or EJVTA, is a simple, short, essentially two-page bipartisan supported bill introduced in the Senate on June 21 as S2082 and introduced in the House on July 26th of this year at HR 4951. I expect others up here, particularly Terry Stroud, is going to talk about it. But to set her up a little bit and discuss what's happening on that front, I want to explain a little bit about what the EJBTA is. The bill was introduced by the original sponsors of the Justice Against Sponsored Terrorism Act, or JASTA, as many of us know it, to resolve 3 discrete technical issues flagged after JASTA was enacted in 2016. It does nothing more than reaffirm Congress's initial intention in enacting JASTA in 2016. It's 5 sections of the bill, and the first and the fifth are essentially non-substantive in the sense that the first one just tells you the title of the bill, the Ensuring Justice for Victims of Terrorism Act, and the last one just tells you the applicability, which is the amendments applied to all civil actions pending on or commenced after the date of its enactment, which leads to sections 2, 3, and 4 as the substantive provisions. Section 2 is called Foreign States, Section 3, Execution of Judgments, and Section 4, Definition of National of the United States. Basically, Section 2 amends a provision of the Foreign Sovereign Immunity Act, Section 1605B, to insert reference to Section 2333 of the ATA, of the Anti-Terrorism Act, to make clear that even if you think that the use of the term person in the ATA prevents U.S. nationals from suing foreign states under JASTA's aiding and abetting or secondary liability provision, JASTA's secondary liability claims are available against the foreign state. So essentially it makes clear that everybody in the litigation has these claims against foreign states, which is contrary to one of the findings in one of the decisions of the district judge overseeing this litigation.
How many co-sponsors?
I don't know, it's like 25, 20?
23 in the Senate.
23? Right.
Yeah, almost a quarter of the Senate.
So, good number of co-sponsors, and it's bipartisan. And let me just say, if you can hold your questions to the end, that would be super. Section 3 in the executed judgments basically makes it clear that the same rights that would apply to executing judgments that apply to other claims under other provisions of the FSIA apply to JASTA claims. And the definition of national in the United States amends a section of the ATA to clarify that what's long been understood to be true, and that is that the term U.S. national includes entities organized under U.S. laws. The bottom line here is that 3 substantive provisions, 2, 3, and 4, are all provisions that the members of Congress who brought us JASTA have said are essential to ensuring that JASTA gets effectuated as they intended. And again, I anticipate discussing the bill more today with some of the others here, but aside from commenting that it's imperative that the 9/11 community voice unqualified support for Congress to enact EJBTA, it's important that we do it without delay. With that, I'm hoping that I've at least touched upon most of the things that have happened this year, and I want to turn it over to Andrew or Duke Maloney to have some additional comments.
Thank you, Robert. Some of you know me already, and many of you don't. My name is Andrew Maloney. I'm a partner at Crimer. Everybody calls me Duke. That's my nickname. I'm a former federal prosecutor, and I am a volunteer firefighter, and I responded to Ground Zero days after the attacks. So I'm a New Yorker my whole life, like many of you, and I'm humbled and honored to be able to represent many of you and collectively all of us to represent the 9/11 community. I should tell you what you really want to hear, I think, and you're interested in is what's going on with the case, where are we, what's going to happen in the future. I am very optimistic about the evidence that we have continued to collect. Literally every month we get new pieces of information, new documents, new witnesses. This has continued for many, many years, but it's accelerated in the recent years after President Biden's executive order released additional documents. I'm not permitted to tell you any of the details about what we've learned until they're unsealed. You heard Mr. Hayford talk about the experts, the Daubert challenges. I should tell you that specifically on the experts that are working for us, working for you against the Kingdom of Saudi Arabia. We have 7 experts, and we have really top-notch experts. We have a former CIA officer who used to brief the president on counterterrorism, Islamic terrorism, former FBI agent who was one of the leading counterterrorism investigators in the United States in Islamic terrorism, a former State Department official, an NSC official, an expert on Anwar al-Awlaki. I'm not sure if all of you know who Anwar al-Awlaki was, but he was an American-born, Yemeni descended preacher. He was an imam who started out in Colorado, but he was preaching at a mosque in San Diego and met with the hijackers on multiple occasions. And Omar Bayoumi, that name should probably ring a bell for many of you, who was a Saudi co-optee of Saudi intelligence. That stuff is now out in the public domain. But Anwar al-Awlaki then went to Virginia and preached at another mosque where other hijackers showed up. So he was an important linchpin. We have an expert specifically to talk about the significance of Anwar al-Awlaki and those touch points. And then we also have a pilot expert to talk about some of the piloting issues and some of the other evidence that I can't really detail at this moment, but some very, very exciting things that are on the horizon. It's not a surprise that Saudi Arabia has tried to exclude those experts because they don't want those experts to testify. And that's the Daubert challenge that Mr. Hafley was talking about. They're trying to exclude the testimony and the opinions of those highly qualified experts. We've also challenged their experts. They have 3 experts, Saudi Arabia now I'm talking about, not the charity case, but Saudi Arabia has a psychiatrist, a former diplomat, U.S. diplomat to Saudi Arabia, and also a pilot to counter our pilot. And we've challenged their testimony because we don't think that they're qualified to give opinions that they have in this case. So both sides are being challenged, as Mr. Hafley referred to. That process has been fully briefed. The court will decide those issues to determine what expert testimony is going to be admissible going forward and what is not. But I feel very good about the expert reports and their testimony. And we have turned those reports over to the FBI to review it for protected material. We've made redactions of those reports because it is our expectation and our hope that they become public. We want them unsealed so that you can read them, so the American public can read those reports and someday hear the testimony. And we're approaching that stage soon where the court will decide what gets unsealed and what doesn't. And that's going to be an important milestone in the case. I think Robert referred to some of the schedule coming up. Saudi Arabia is supposed to file a motion to dismiss for the second time on October, sorry, the date here, October 6th, I believe. Yeah, October 6th, and our opposition response is due December 8th. And then Saudi Arabia gets a reply. They get the last word since it's their burden to prove their motion to dismiss, and that is due on January 19th of 2024. So after the January reply, we'll be requesting the court conduct a hearing, which will be public, which you can attend. We certainly encourage everybody to attend these hearings because they're important to show your presence to the court and to Saudi Arabia. We don't have a date for any hearing yet. I'm not sure how the court's going to handle it, but we're going to certainly request that. Then the judge will decide whether or not to grant or deny the motion to dismiss. That's going to be a huge decision, a huge turning point in the case after all these years, because the judge is going to have to go through the evidence that we're going to put forward in our opposition. And if, no matter what he decides, most likely that's going to be appealed, but it will really send a message to the parties in the case about what the next steps are. If he denies the Saudi Arabia motion to dismiss, we are entitled to get additional merits discovery in the case and move forward, hopefully to a trial someday. So that's really the roadmap going forward. But we feel pretty confident about the material that we've guarded in the last several years, and Saudi Arabia has continued to rely almost exclusively. This is a little, maybe I shouldn't go into the personal opinion, but they've relied on the 2004 9/11 Commission report that they claim exonerated them, which we disagree with, but there's been an additional follow-on investigation after 2004 where a lot of new evidence and information was deduced, and we've got a lot of that now. We still want more. I think Robert may have touched upon, I'm not sure if you did, on the Gitmo detainees and the plea bargain issue, one of the things that we really think is unfair is that the lawyers representing the terror suspects at Gitmo have been given certain documents that have been classified that they haven't given to us, to the lawyers representing you, and we're demanding that we get all those documents. So that's an issue that we're hot on the trail to push the government to give to us. The FBI is still, I think, supposed to give us additional documents. We're continuing to fight with them to push for the last set of documents there, and we're not going to give up, so we're going to continue to fight that. But what we have right now, I feel very optimistic in being able to convince the court that the Saudi motion to dismiss should be denied. I think Robert also touched upon the Sudan decision that came out in August, only about a month ago. Judge Daniels, in an important decision, denied the Sudan's motion to dismiss the case. Some of the language used in that opinion I thought was very good, could help be a harbinger for what he might do in terms of the Saudi motion to dismiss. We don't know. One of the things he did do, however, was overrule one of the parts of Magistrate Judge Metburn's order, which said that the secondary liability, there's two kinds of liability, direct liability, and then there's secondary liability for aiding and abetting. If you aid and abet and provide material support to a terror organization, you can be held liable under the Anti-Terrorism Act. Magistrate Judge Metburn said that that applies under JASTA. Judge Daniels said it does not apply to a foreign sovereign, a foreign state like Saudi Arabia. So ultimately, it doesn't have a direct effect right now, but we believe it's an important legal issue that could be helpful or hurtful going down the road, which is exactly why we've asked Congress to fix that, that ambiguity that Judge Daniels claimed that the definition under JASTA, the definition of person or entity, does not include a foreign sovereign. So the pending legislation would fix that and make it very clear that yes, it applies to foreign sovereigns as well. So that's an important piece of legislation that we think should get passed, and the families have been very supportive of it. Terry Estrada is going to speak to that, but it's an important thing that's on the immediate horizon right now. I think that's about all I have at the moment, because Robert covered so much, and I'll sit down and I'll turn it over to John Eubanks from Marriot.
Thanks, Duke. First of all, I just want to say, and I know I probably say this every year that I'm allowed to come and speak before you all, but it is always an honor to be able to speak in front of this gathering, because it is an honor to be able to be on this stage representing people who have gone through such a horrific act. And we just thank you collectively for the ability to be able to be your representatives in court. One of the things that I wanted to draw upon about, I am going to talk predominantly about the U.S. Victims of State-Sponsored Terrorism Fund and the Iran Fund, but I did want to touch on one issue with the Sudan judgment that I know raised some eyebrows in the client community. There is one portion of Judge Daniels' opinion that touches upon the impact of having participated in the Victim Compensation Fund back in 2002 and 2005 time period, and whether that impacts your ability to bring these claims. It does not. I want to make that absolutely clear. While there is language in Judge Daniels' opinion that says that people who did versus those who didn't participate in the VCF might have different avenues to pursue, or might have different strategies that they might be able to pursue, in reality, there is no difference. The only thing that might be different is if someone who did not pursue a Victim Compensation Fund claim, they would be able to pursue a negligence claim. The problem is, the court has ruled out negligence in this case. And the parties that were suing didn't do this negligently. This was on purpose. Intentional acts, everybody's in the same boat. Whether you participated in the VCF or you didn't, you're all in the same boat. And I wanted to make that clear because I know that there's a lot of people who got confused. That language got circulated to a number of people, and I wanted to be clear that just because you were in the VCF doesn't impact your rights to be able to be in this case and be able to pursue all of your rights for being intentionally harmed. Now, moving moving to the Victims of State Sponsored Terrorism Fund. Now, if you participated in the January 2023 payment, you're probably wondering, what was that? Because it was slim to nothing, I guess, for those of you who were able to participate in that, what we call the fourth round payment. It's our belief, we haven't been told this specifically, that the Special Master of the USB, which is what we call it, the State Sponsored Terrorism Fund, the Special Master had not issued payments for 2 years. And I think she felt like she was under pressure that she had to do something. But the problem is the fund didn't have a lot of money at its disposal in December of 2022. So what they did was they made a payment that was minuscule, but a payment nonetheless. And so I just kind of wanted to make that clear to a lot of you, because I know people were wondering, well, why did they do this at all? I think there was pressure, honestly, from the Special Master that she needed to, I don't want to say do her job, but she felt like there had been, since she had been appointed in early 2021, there had not been a payment. And so she authorized the payment for January 2023. And while they were small, it was something. She wasn't going to make the same mistake in 2024. So as your lawyers have probably told you, or you've seen on the fund's website, there will not be a distribution in January 2024. And the reason for that is that since the beginning of the fiscal year for the government, which is October 1st, 2022 through the present, the fund has only brought in an additional $51 million. That's interest and forfeitures. So there wasn't much money left over after the last payment was made, and there's certainly not enough to make it any more meaningful than this past payment was, and she didn't want to go through that again. Again, this is speculation based on, I think, while the Special Master has not outwardly said she didn't want to make the payment because they were too small this last round, I think that's really the truth behind it. Now, when I was up here last year, we were talking about the potential for a lump sum catch-up payment. Well, in December of 2022, with a lot of our clients' support, with lobbying in Congress, with supporters in the Senate and in the House of Representatives, in December, as part of the omnibus budget bill, the lump sum catch-up payment was made, or was authorized. And then later in the year, in the spring, the payment was distributed. Now, I want to be clear that the only people who were eligible to receive catch-up payments were those who were left out of the fund by reason of the statute creating the fund. So those who participated in the Victim Compensation Fund, this would be the estate of someone who was killed. This would be the spouse of someone who was killed, or their dependent children or other dependents within the household. Those individuals were those who were included in the lump sum catch-up payment because in rounds 1 and 2, they were specifically excluded by the statute and by decisions from the Special Master. That's not to say that other family members who didn't receive payments in those earlier rounds shouldn't have gotten a catch-up payment. It's simply the mechanism that was adopted by Congress was to pay those who were left out, not by any reason of their own, but by reason of the way the statute was drafted and by the way it was interpreted by the Special Master. I know I've gotten a lot of comments about that, and I sympathize with everyone who was not able to get that lump sum catch-up payment. And I'll talk about those who became eligible in the 4th round for the first time in a second, because that is another issue we're working through. But in the legislation that adopted the lump sum catch-up payment, there were another few issues that are important to all of us, to everyone who has a claim with the fund. First, the GAO was tasked with creating a report. So the GAO is the Government Accountability Office. They were tasked with issuing a report to recommend how the fund can bring in more money. what methods they can employ to better populate this fund with additional money. I have spoken with the GAO about this report. I know others at different firms who represent many of the clients in this case have also spoken with them, given our recommendations, and told them what we believe might be a good route to take in terms of how to make this a better method of paying on these judgments against Iran. We expect that the GAO is going to issue a report later this fall, and at that point, we'll have a better idea of what they were able to determine just looking. They can look a little bit more behind the scenes on what the government is doing and what they can do versus what we can see from the outside. So I'm curious to see what they're going to come back with later on in the year as to what methods they can employ to give us additional funds going into the state-sponsored terrorism fund. The other point that was created as part of the legislation was to create a lump sum catch-up fund for another group of plaintiffs who have claims on the non-9/11 side. So these were victims of the 1983 U.S. Marine barracks bombings in Beirut, and also the victims of the 1996 bombing of the Khobar Towers in Saudi Arabia. Now, those two groups have been explicitly excluded from the fund because they received money from other sources outside the fund. They were able to lobby and obtain a catch-up payment that would allow them to receive payments from the fund on a catch-up basis, but not on an ongoing basis, with a specific appropriation from Congress. Now, Congress appropriated $3 billion for this distribution. Our understanding from the attorneys who represent these folks is that at most, what they believe that catch-up should amount to is about $1.3 billion. And they're not even sure if it's going to be that much, but $1.3 billion out of a $3 billion appropriation. Anything that is left over after that lump sum catch-up payment is made to the Beirut and Khobar plaintiffs is supposed to flow into the fund's general balance, so to go to all eligible claimants. So if it's 1.3 billion, there's 1.7 billion left over. That's split 50-50. 50% goes to the 9/11 side, 50% goes to the non-9/11 side. That would be an $850 million increase in funds available to be paid, likely in 2025. So while we're not seeing a payment in 2024, there very well may be a payment in 2025. At the latest, 2026. And the reason why I say that is that there's certain timelines that were laid out in the law in December that gave the Government Accountability Office, again, a year from the date that legislation was passed to issue a report as to what the lump sum catch-up payments should be. There's a time period where comments can be made, and there's a time period for them to issue the final report. Once the final report is made, the special master then has technically up to a year to distribute the funds. So what we're looking at right now is that probably early spring of next year, of 2024, we will get that GAO report finalized, and we believe that that lump sum catch-up payment will begin to be made to the Beirut and Khobar families. Depending on how quickly or how slowly the special master distributes those funds, we may see that money flow over to the general fund and be made payable in January 2025. So we're going to keep an eye on that collectively. Up on the stage right now, we have Motley Rice and Kreindler. We probably collectively represent around 60 to 70% of the claims in the fund. So we're talking about a lot of people here who will be able to participate in this next payment round. Sources of payments. Now, I know that there has been a lot of discussion in different places about different places where money might be able to come from. The name of the corporation called British American Tobacco has been spread around a little bit, and let me give you a little background on that. In April, British American Tobacco and the U.S. Department of Justice and the U.S. Department of the Treasury engaged in discussions about British American Tobacco's involvement with North Korea. North Korea is a designated state sponsor of terrorism, and British American Tobacco had engaged in commerce with North Korea, and they were trying to hide their transactions and trying to hide the amount of money that they were being able to reap from selling their products in North Korea. There was a fine by the Office of Foreign Assets Control, which is part of the Department of Treasury, for $508 million. There was also a collective agreement that they would pay $692 million, which includes that $508 million figure, to the Department of Justice and to other agencies within the government. Now, when that first came out, my thought was, okay, this is going to be paid out this fiscal year. There's going to be a payment. We're going to see a payment in January 2024. But when we look at the balance sheet of the fund each month, it's not going up. And we finally got our hands on the deferred prosecution agreement against British American Tobacco. It seems that the payment schedule doesn't start until this month. So money is likely not to flow into the fund until the next fiscal year, until fiscal year 2024, so after October 1st. And so we anticipate that money from the British American Tobacco issue is going to flow into the fund for fiscal year 2024, which would be a payment in 2025 on those funds. There's been some discussion as to whether or not that money is going to go into the fund or not. Trust me, we've had this discussion with people both in the GAO, but also within the Department of Justice, making clear that that money needs to go. This is specifically the type of fine that needs to go into the fund, that was intended to go into the fund, and we are going to keep track of when the payments are made to make sure that the requisite payments are flowing into the fund. If they're not, I know people on the non-9/11 side have already reached out in droves on this issue. We are going to be joining them to make sure that those monies make it in. Now there's one other issue before I talk about the fourth round issue. Well, there's two more issues. There's also been talk about now Robert talked about the Afghanistan Bank assets. And there is legislation that was introduced in the House to use those funds, which is approximately $3.5 billion, to go into the state-sponsored terrorism fund to be able to spread to a larger group of terrorism victims. The problem, though, is, first of all, if the executive branch decides to do that, that is their prerogative, that is at their discretion. They can do it. But the way that the state-sponsored terrorism fund is structured is that monies from fines against designated state sponsors of terrorism flow into this fund. Regardless of what we think about the Taliban or think about the government of Afghanistan as it exists today, neither of them have been designated as a state sponsor of terrorism. The Taliban is designated as a terrorist organization. The government of Afghanistan, our government still recognizes the prior government as the real government of Afghanistan. They don't recognize the Taliban as the government of Afghanistan. That kind of flows back to why the Afghanistan Bank assets are not available to pay on Taliban judgments in this case. The court said they don't want to make a judgment that is strictly within the executive branch's discretion to recognize the Taliban as the government of Afghanistan. So, I don't know that this money is going to flow into the fund. I don't think that legislation has gotten much, if any, traction because there is this issue, and I believe the State Department has opposed it as well. The idea is that with that $3.5 billion still out in the public realm, that it's potential that if the Taliban gets overthrown and a quote-unquote legitimate government of Afghanistan comes back into power, that money would be remitted back to the Afghanistan Bank, which is the central bank of Afghanistan, to support their economy. We don't know what's going to happen. But right now, that money is not flowing into the state-sponsored terrorism fund. And while it would be fantastic for all of us who have claims with the fund, right now that is not something that's going to happen. Now, last year, I had someone ask questions about non-U.S. nationals in the fund. So I want to take a few minutes to address that issue. Over the course of the past year, two of the law firms have worked together on motions to be filed on behalf of these individuals under JASTA. So JASTA does not differentiate between whether you are an American national or a non-U.S. national, because the terrorist attack at issue in a JASTA case happened on U.S. soil. So if it happened on U.S. soil, technically there should be a right for anybody to bring a claim who was killed or injured in the attack that happened in New York, in Washington, in Pennsylvania. So the motions that were filed, we believed had very good merits. Only recently did Judge Netburn issue a recommendation that they be dismissed or denied, not because they lacked legal merit, but because there is more confusion, it seems, in her mind as to what law to apply. So under a JASTA case, as Robert was talking about earlier, if you're a U.S. national and the country doesn't have sovereign immunity because of JASTA, because they supported an act of terrorism on U.S. soil, then technically you can bring a case against that foreign national under what's called the Federal Anti-Terrorism Act. Well, the Federal Anti-Terrorism Act only applies to U.S. nationals. The non-U.S. nationals would have to pursue claims under state law, so under wrongful death, survival, conscious pain and suffering. The problem is that the court could not decide what state law to apply. We have recommended that she apply the state of New York's laws on this issue. It has been turned around back to the plaintiff's lawyers to come back to her with a proposal as to what law to apply for each individual separately, as to where did they live at the time? Were they a U.S. resident? Were they domiciled in another country? What's the law of the other country? So for those who are not U.S. nationals, who don't have a judgment against Iran, who aren't in the fund, we want to let you know we are still pursuing this. We're not leaving this issue behind. We're trying to not leave anybody behind. You all suffered, and we're just trying to find the right legal path to be able to make those claims viable. Now, the last point I want to talk about is the fourth rounders, and that's kind of a term that many of the people who were in this situation have used themselves. So people who became eligible for the fund for the first time with the 2023 distribution in January, but who otherwise would have qualified for the lump sum catch-up payment. So this will be the estates of people killed on 9/11, the injury claims of people who were injured on 9/11 in the buildings or in the immediate surrounding area when the buildings fell, or the spouses or the dependents of those who were killed on 9/11. We, from the beginning, from January of this year, after the legislation was passed, we were on the phone with Senator Menendez's office, Senator Schumer's office, saying, we need to get these people included. And we don't know what the special master is going to do. So we reached out to the special master. I wrote a letter on behalf of our clients. All of the law firms collectively wrote a letter to the special master just saying, these fourth round claims need to be included. And you have the discretion to do so. The special master has determined she does not have the discretion to do so. So I do want to put that out there and make that clear. She has said she does not have the discretion. She has to follow the law as it was written. And her claim is that the law as written stops at the third round for the lump sum catch-up payment. We don't stop there. We have been working still with the offices on Capitol Hill, trying to find a mechanism to get this legislation through. Honestly, the EJBTA is the priority right now. And what we don't want to do is create a situation where there becomes a form of fatigue. I know that sounds horrible, especially if we're leading into yet another anniversary, but politicians are politicians, and they can get fatigued by a certain issue or by a certain set of people who have what they view as an agenda that they want met. The EJBTA is bigger for the entire case, for the Sudan case, for the KSA case, and honestly, throughout the anti-terrorism litigation realm. But that doesn't mean we're leaving this forefront issue out. There are moves in Congress to try and find a way to at least make a partial pick, to pair together the fourth rounders with certain people who were in the Beirut Kohar situation who aren't part of that catch-up pickup for one reason or another. There are a lot of different methods or mechanisms that are being pursued in discussions with those who have been our champions in Congress, and also with those who haven't been at the forefront of this fight for the past few years, to try and find some form to get these people compensated in the way that they should have been compensated. Again, it feels like a military thing almost, but we're trying not to leave anybody behind. And I know we don't publicize a lot the efforts that we're doing because sometimes they don't come to fruition. And we don't want to get hopes up where they might be dashed later. But we want to make clear that we are fighting for the rights of everybody in this litigation. And that leads to one last point that I just want to touch on briefly, because I deal with a lot of the client issues within our firm, and honestly, we have a lot of clients. So the latent injury claims, and I'm only going to touch on this very briefly. So claims of people who, against Iran, who were killed by later exposure to the World Trade Center, to Ground Zero, to the dust cloud, basically, over Manhattan, and who contracted different forms of respiratory issues, cancers, and whatnot that led to their deaths. The judge has issued decisions saying that the activities carried out by the terrorists and their helpers caused those injuries. It was not clear whether or not that the judge would come to that conclusion, that those injuries were caused by it, because cause from a legal perspective means that they had to be reasonably foreseeable by the person who carried out the attack. Whether they were reasonably foreseeable by the terrorists or not, I'm sure the terrorists are very happy that it spread beyond those who were killed and injured that day to those who were exposed later. What we don't want to do is create a situation where there are different classifications of plaintiffs in the case or victims of these attacks who are fighting against each other. And I know that's hard to do because everyone's in a different boat to a certain extent. But what we need to do is be unified as a group as we approach Congress, as we approach the press, and as we approach each other. I'm not going to weigh in on the rights that everyone has. But what I do want to do is just to say our job is, as the lawyers in these cases, is to try and make sure that we're promoting things before the court that are for the common good for all of our plaintiffs. And for better or for worse, for some of you, those plaintiffs include the victims who were killed, their parents, their siblings, their spouses, their children, people who were injured on 9/11, and now people who were injured not on 9/11, but suffered as a result of being exposed on 9/11. We don't know where that's going to go. It may be that in the future, a defendant who actually is defending against this case will make some arguments about who should or should not be a plaintiff. But at the present time, the court has made these decisions, and we have to stay with what the court has decided. So, again, it is an honor to be able to represent all of you within the whole litigation. I really don't I don't personally represent all of you. Those who are represented by Motley Rice, it is truly an honor for me to represent you, but if you're within the multi-district litigation, we all, the three of us sitting up here, we represent all of you. We're trying to pursue this litigation for all of you together, and we appreciate you entrusting us with this, and I thank you for your time. I'm going to pass it to Terry Strada, who's going to talk to us about the legislative efforts in the EJBTA.
Thank you.
Thank you to everyone here at Voices for putting together this very informative forum the last 2 days and inviting me back again to speak on the advocacy work that I do. I've been advocating since 2002 when I joined Motley Rice and a group of 9/11 families and survivors to announce to the world that we were suing the Saudis for the role that they played in 9/11 and we were going to bankrupt terrorism. I worked with Congress to declassify the 28 pages for 4 years on the enactment of the Justice Against Sponsors of Terrorism Act, JASTA, on the introduction of the 2021 Transparency Act, and now for the EJBTA. So the Saudi litigation is my lane. Everything I do and have been doing over the past 20 years is to move the litigation forward as the best I can when I go to Congress and advocate for our rights. I was asked at the very last moment at the end of July to help with the LSCUP, and I was proud and honored to go down to DC and use the relationships that I've made over the years to help get the LSCUP over the finish line. But the work that was done on that was completely done by a very impressive group of 9/11 widows and children, and it took a very long time to get that accomplished, but they did it. While we have made great strides, unfortunately, the fight for justice continues today. As many of you will recall, and I'm going to just touch base a little bit back on what Robert was explaining about JASTA and how we got to the EJBTA, just so everybody has a real understanding of it. It took 7 years to enact JASTA, and it became necessary because the courts were misinterpreting current law and dismissing the Kingdom of Saudi Arabia by ruling they were entitled to sovereign immunity, which they were not. No one is entitled to sovereign immunity. We are involved in a terrorist attack on American soil. In 2016, we were able to persuade Congress to show a united front and override a presidential veto and enact JASTA, which allowed the Kingdom to be reinstated into our lawsuit and for jurisdictional discovery to begin. Earlier this year, the court once again misinterpreted current law, and ruled aiding and abetting could not be applied to a foreign country. That is exactly the opposite of what JASTA is intended to do. In order to reverse that incorrect interpretation, we are asking Congress to show their unity again and pass the Ensuring Justice for Victims of Terrorism Act, the EJBTA. As Robert explained, it is a technical fix bill, and that will allow aiding and abetting to be applied correctly again, as Congress and JASTA intended, and permit us to continue our pursuit of justice. This is it is just a necessary piece of legislation. If we're going to achieve the justice we deserve, it is very simply written, and we should all support it for our lawsuit against the Kingdom to continue. I know a lot of you are aware of this, since letters have gone out to you from attorneys' offices asking for signatures of support to be distributed to Congress. I'm here today to tell you that our letters are getting sent to all members of Congress. We are receiving a lot of very good positive feedback, and letters have all been sent into the White House to the President as well. In addition to the letters that we've been writing, I've traveled to DC a couple of times, most recently just last week, to discuss the legislation and to meet with congressional offices and leadership to relay how important EJBTA is and thank them for the work that it's going to take to move it to the President's desk for signature. The recent letter that the attorney sent out did have over 4,000 signatures on it, and the letter that Angela and I sent out beyond the 9/11 community received over 1,000 signatures. So we just went out a little bit beyond the 9/11 community to ask other people that support the legislation if they would sign on to the letter. So those were really impactful to send over 5,000 signatures into Congress recently. What we are concerned about and what we are talking about a lot with the administration is to not trade away our right for justice in the peace deal with the Middle East that's happening now between Saudi Arabia and Israel. That is something that is being talked about as well when I'm in DC. We did learn that recently an advisor to President Biden is asking Senate offices to kill the bill because of the potential peace deal between Saudi Arabia and Israel. I cannot confirm with you today where the president stands because, as all of you know, he is going to Alaska and will not be here commemorating the anniversary at any of the sites. And we have not yet heard from the White House how they're going to respond to the letters. But rest assured, we will continue pressing for that to come in the coming days. In addition to sending out letters, I am not here today to tell you this will happen simply because it is the right thing to do and therefore should be easy. We are always up against the kingdom, whether it is in the courtroom, in the halls of Congress, or with the media. The kingdom is, as I am sure most of you are also aware, trying to take over professional golf with the merger of LIV Golf and the PGA. LIV Golf is nothing more than a PR stunt to help improve the kingdom's image on the world stage. I personally find it offensive and have been very outspoken on this topic, pointing it out to the media repeatedly, the role that the kingdom played in supporting Al-Qaeda and giving Osama bin Laden the resources needed to build Al-Qaeda into the deadly terrorist organization it became, while also giving the logistical and financial support needed to carry out September 11th. In that respect, LIV Golf is the gift that keeps on giving. For years, the kingdom would point to the 9/11 Commission as exonerating them, and I do not see that argument surfacing in the news the way it used to. So I am feeling confident we are making strides in the public arena and with the media that the release of declassified documents over the past 2 years from President Biden's executive order confirming the kingdom's culpability and the 9/11 Commission did not exonerate them. Going forward, I am making efforts with other 9/11 family members to find a candidate running for the Republican nomination to be a champion to the 9/11 community and take a pledge. If they will win the nomination and the general election, would they do what no president has done and hold the kingdom accountable? While it's challenging and takes educating them on the topic, I am hopeful one or more will be agreeable to stand with us and do the right thing. I cannot stress enough to everyone today that while declassifying or further unredacting documents already released is important, as everyone here has told you today, it is the EJVTA that is the most important issue we need to support Congress to focus on right now. Have that remain their focus until it is signed into law by the president. Please, you can follow the progress we are making and any updates on my website, 911familiesunited.org. And that concludes my update on what advocacy work I have been doing and will continue to do. I wish you all peace, love, and support as we navigate another painful anniversary tomorrow. Never forget and never again. Thank you.
Thank you, Terry. Thank you, John. Thank you, Duke. I think we have just a few minutes left. I think it'd be a good time to do some questions from some folks here, but I have a few questions I want to start off with the panel. The first question is, Terry, do you understand, as I do, that the administration advisor that's pushing back against EJVTA is using the same rejected Saudi-based arguments that Congress rejected when they passed the first round in 2016?
To some extent, yes, but they're adding now that the peace deal would be in jeopardy if the EJVTA were to pass. We basically like to say the sky is falling and everything will go wrong with our relationship with the Kingdom of Saudi Arabia if we try to hold them accountable for 9/11. And that's simply not true. So the answer is yes, but now they've added that
In
piece.
2016 was basically they're going to pull all their money out of the U.S. economy, and now it's just a variation on the same theme that don't hurt our relationship with the Saudis. And if you do, they'll reject everything that of their relationship about us. And when JASTA got passed in 2016, did the sky stop falling? Did the world stop spinning?
Nothing happened. None of their claims came to fruition, and that is what we go back and tell them again. Nothing happened then, and we don't see anything like that happening now.
One more quick question for you, Terry. Is it true that in July you put up a great big billboard in Times Square related to Live Golf?
Yes, I don't know if anybody saw it because Fox News and CNN both covered it, but yeah, we had a large billboard in Times Square highlighting that the Saudis are supporting Live Golf or PJT, but they also supported the 9/11 attacks. They also supported Al Qaeda. They also support the war in Yemen, you know, the murder of innocents, and so that ran for a week every 15 seconds, and they were not happy with that. If I could just add one thing before we go on to other people, if you want to get involved and help, if you reach out to your own senator now, because a woman came up to me, sorry. Yeah, right there.
Deborah.
Deborah. So she's already reached out to Senator Sanders. She's from Vermont, and he's going to come on to the bill. And that's the best thing you can do. Is just reach out to your own representatives, your own senators. Go on the website, then you will see everything about it, and you'll be able to tell them exactly why you need it if you can't remember what we talked about here today. But ask them to come on as a sponsor. That would be
Can
very
you just
helpful.
give the website one more time?
9/11familiesunited.org.
Is there any questions?
I have a comment.
For John Eubanks, John, there's one family that does have the Afghan judgment. Is it possible for our attorneys to get us Afghan judgment to go into the death funds?
There is one, well, the Smith case, I believe is what you're referring to, and for better or for worse, the judgment they have is against the Islamic Emirate of Afghanistan. The Islamic Emirate of Afghanistan is the name of the Taliban-controlled entity. I don't think the Smith case is going anywhere. They were part of the same issue of not being able to access the DAB assets as the other cases within this multi-district litigation. So I don't think that that's going to be anything that moves forward either.
And there are motions pending before the court, or there were, and there will be, to get judgments for the rest of the folks. And
Correct, but I think the question was, they have a judgment against Afghanistan.
Okay.
And so, and that is a slight difference, but it was a difference without any meaning even for Judge Daniels, because their motion was adjudicated as part of this same motion, and they're at the same appeal up to the Second Circuit.
One more question, John, and
Sure.
they don't go on the side. And full disclosure, I lost my husband on 9/11. So a lot of the 9/11 families were very concerned about two current things, the BCF waiver and Section 4 of the EJPTA. And that is simply from a history and background of not being included in this for 9/11. That's where it comes from. People are very scared. And they feel
Repeat your question, John, so everybody.
Sure. So the question was concerns that have been raised about BCF1 waiver, which is something I discussed about from the Sudan decision. The BCF1 waiver issue that has been raised is if you participated in the BCF, particularly BCF1, and received a payment, then under the law that created the BCF, it would limit your ability to pursue certain remedies in court. The problem is the certain remedies that you are limited in pursuing are those related to negligence claims. And this case is not about negligence. The case is under the Anti-Terrorism Act, under JASTA, even under the state common law, wrongful death, survival kit claims. Those are, I'll become a lawyer right now and say, these are intentional tort claims. They're intentionally damaging people. Intentional tort claims were not included in that waiver. So you're really all in the same boat. The VCF, whether you participate in the VCF or not, there is no difference in our mind. It doesn't change our strategy as it pertains to anybody. It doesn't limit your ability to recover against people who are intentionally acting to support Al-Qaeda or the Al-Qaeda terrorists who carried out the attacks. On Section 4, I'm going to let Robert address that. I mean, I can address it, but I think Robert is probably in a better position to do so.
I want to hear the question again, but first I'm realizing that we're over time a little bit. I know I could be available after this for questions. So before we close, I just want to thank everybody for being here. Thank Voices absolutely for putting on a fabulous program and inviting us all back. If you want to talk to me afterward, because I think you want to wrap up, right?
Yeah, and I was going to make the point that they would be around to ask questions to individually during the break and so forth.
Okay. Yeah, because I saw that there were some other hands that people want to approach us separately. Why don't you come up afterward and I'll take your question, okay? Thank you, everybody.
Thanks to all of the presenters.
Born and raised here in Washington Heights. That was a very particular decision that was made by my parents to raise my brother and I in New York City so that we could benefit from all of the things that the city had to offer. My parents are unfortunately both passed, and as my colleagues know, unfortunately my father passed 2 months short of hearing that I had gotten this position, which he would have been, for those of you who know Yiddish, he would have, no. So I really do so much of the work and everything I do based on where I came from. My parents were really quite remarkable. They were civil rights activists, women's rights activists, anti-war activists. Among other things, my mom worked in the New York City public schools, most notably as a social worker who worked with students who wouldn't come to school. And one of the things that she did during that time, the school that she worked for is no longer there. It used to be on the east side of Manhattan in about 135th Street. Many of their students came from the Southeast Bronx. And when children did not come to school, my mother would go out to try to go to their homes and find out why they weren't attending school. My mom, we used to call her Little Mommy, she was probably about up to here on me. And she would sometimes from there take a cab to go over to the Southeast Bronx to Fox Street. For those of you who know Fort Apache, you know where that is. And the cabs would not drive down the streets where my mother would have to go. So she would get off on the corner and she would walk down and she would go to people's homes and try and find out why the kids were not coming to school. And it's not what people think. The kids were not cutting school because they were playing around or dealing drugs or doing any of the things that we worry about our kids doing. The vast majority of them were caring for younger children so that their parents could work, and or they were the only ones who were caring there, or they were actually at work themselves so that they could help support their families. And these are the lessons that my mother brought home to me. My mother was the most well-spoken person that in all these years I've been alive, I had and have ever met. And so that always resonates with me to make her proud when I have to speak to folks as well. My dad was born and raised in the Bronx. He is the son of immigrants, so he was a first-generation American. My grandparents came from Austria and from Bessarabia, and my grandfather started a successful commercial laundry business that had existed before the Depression and before the war, and then kept running the whole time through that time as my other relatives were fleeing the Holocaust. He employed every single person who came to work in that laundry and gave them a way up. And it's, again, one of those lessons that I learned, which is that when you have privilege, you have responsibility. And so that's what has driven my life and my career. My dad was, by business, a hotel man, but most of his career outside of what he did during the day related to helping others and following in history. My dad was the president of the City Club of New York. For those of you who are longer New Yorkers, you may remember it, a very active civic organization. And in fact, it was his idea to come up with a newsletter that's called the Gadfly. And if you know what that stands for, you'll understand the significance of that. He also had taken a class when he was a young man with W.B. Du Bois, which sent him on a lifelong interest in the Reconstruction era of American history. And the result of that was, after years and years of my dad collecting items, of doing history, although he was a businessman, he wasn't a historian, he wrote a book called The Heroes of Reconstruction, so that he could let people know about that lost part of our history. And he followed that up by writing 10 more books on hotel history, and in fact won Historian of the Year 3 times from the hotel organization that oversees those things. So, first of all, I'm not going to write a book. So that piece, I don't want to think I have to follow in his footsteps, but the rest of it was really to have this foundational part of myself. I went to college. After college, I became a police officer. I shocked my nice Jewish parents, because nice Jewish girls don't become police officers. So, and I thought that I would stay there for 2 years, but honestly, the first day that I put that uniform on, I felt like a hero. And I wasn't a police officer here in New York City, I was in the Philadelphia area, and I ended up staying for 8 years total, the 4 middle years of which I went to law school at Temple University, and after that, leaving that department as a lieutenant, I came back home. And I came back and worked in the Manhattan District Attorney's Office under Mr. Morgenthau. One of the things I'm very proud of, I prosecuted felony narcotics during the crack epidemic. I handled felony child abuse cases, as well as worked in the Special Projects Bureau, handled serious felonies and homicides. It was an amazing opportunity to seek justice, which is something I think is a key part of supporting victims and trying to make our community as a whole be better, function better, create a pathway forward for people. I did spend 1.5 years in Central Illinois as a prosecutor, and then I came to the Washington, D.C. area. I worked for an organization called the National Center for Prosecution of Child Abuse. I left there as their director. We taught people how to investigate and prosecute child abuse cases. Are you hearing a theme here? My career is related to working with, advocating for, fighting for, and supporting victims. I then went to work for the federal government. I worked in the SMART office, the Office of Sex Offender Sentencing, Monitoring, Apprehending, Registering, and Tracking. And if you can say that again that fast, you get a prize. I worked there with the Indian tribes, helping them implement the Sex Offender Registration and Notification Act. And then I was promoted. I went to the Office for Victims of Crime. I was the deputy director of the division. And relevant to this work is that I oversaw our mass violence and terrorism program response to victims, both locally as well as our international victims crime program, which paid to compensation program that paid to American victims of international terrorism overseas, and the people who worked in our consulates. And then I did start like at 5 doing all this, by the way. Before I came here, I worked on a special project for the Office of the Deputy Attorney General to create another fund, which was to set up a fund for the Amy, Vicky, and Andy Act, which is for victims of trafficking and child pornography. And then I was appointed by the Attorney General to come here, and I'm so deeply humbled and honored to have this position as the permanent special master of the September 11th Victim Compensation Fund. I work with extraordinary people at the fund, and I am absolutely blessed and graced to understand and to see how unique and committed they are. At that moment, I'm going to turn it over to Stephanie Langston, our Deputy Special Master, to tell us about transformation.
It's hard to follow that. But we are thrilled that Allison joined us in March. I think it's great that this marks her 6th-month anniversary with the VCF, and the team has been very energized and excited, and her background, as she just mentioned, has been just such a terrific fit for our team and, more importantly, for our clients. So I am going to briefly talk about our transformation effort, which we are incredibly excited about. This is something we started talking about in 2019 when we were made permanent, thanks to the efforts of many of the individuals in this room, the advocates. And it was the first time we had a chance to look at our program as a long-term, fully funded program. So the transformation effort is a reimagining of the VCF to make sure that we are here to support claimants and their families through 2090. We are transforming in many ways, but the biggest part of our transformation is the transformation of our online claim system. Our current system is old, it's outdated, and we have been working over the last year or so on the development of a new system that focuses on improving the claimant experience, most importantly, reducing the time it takes from claim submission to award, and again, ensuring that we are here through 2090. So the system is called MyVCF, and it's going to, we hope, achieve several key goals. Number one, streamline and simplify the claim filing process. So for anyone who has filed a claim with us, you likely know that you have to do parts of it in the online claim form, and then you might go to our website and try to find the information you need to help you answer the question. This is all going to be in one system with tips and guidance to help you understand the questions that are being asked. The questions are being done in a way that's much simpler, using plain language. We hope that that will ease the process and make it very clear what you need in order to file your claim. It's going to guide you through the process. And again, another important aspect is it won't allow you to submit your claim until you have completed all of the required questions and have uploaded the documentation that we need in order to review your claim and be able to issue the award. So we have been making tremendous progress in the development of the system, as I said. And I'm actually going to let Allison share an announcement, and we also have a short video about when the system will be available. So Allison, I turn it back over to you.
Thank you, Stephanie. And this is one of those things, rank has its privileges. Here's one of them. I'm extremely happy to announce that we will be launching MyVCF by June of 2024. And we have a date that we're set out for, which is to be by May 28th, but just in case. We want to make sure that we have, that we'll do it before June 2024. There will be many updates as we go through now and then. There's a lot of things that happen in chunks. If you've ever been involved in a large system and setting it up and adding information, we have to take information from our old system and put it in the new system. There will be extensive communication as we do this. There will be training modules that will be online and materials that are available prior to the launch. We will have expanded assistance. Some of you we know have worked up with our helpline. They will be expanding in size as well as receiving extensive training to help people who will be calling into them. We also have other in-place people to assist with folks using the new system. And as we prepare for this, MyVCF, I'm really happy and really encouraged by the support that we receive from this community. And we do have a very brief video we'd like to show about MyVCF, if you guys would help us. The answer is yes to this question. Were you there? Encourage them, whether they're sick or not, to take a few minutes and register with the VCF. It's simple, it doesn't take much time, as you saw there. They don't need any special information. It asks a few simple questions, and it may hold information for them and have them know and learn later on if they do become ill, that they then can submit a claim to try and get compensation from the VCF fund. At the end of the day, the VCF is here to help people, and we want every potential eligible person to know about the VCF. So one of the main things that we will be working on, and that we have been working on, is we are getting a new communications director, and we are focusing on outreach. And we are focusing on outreach in ways that we've never been able to do before. And we are going to be able to do that because of the efforts of many of you in this room making the VCF a permanent program until 2090. So I thank all of you so much, and we're going to move on to our next session.